Yes. All right, everyone, I'm going to call the docket. If you're here, let me know that you are here. The 187 District Court is still going to be following all COVID guidelines. I know some people think maybe COVID was a dream, it did not exist. I'm a firm believer that it did exist. So I'm still going to have plexiglass. And if you are not on the docket, you will need to wait outside in the courtroom. We are still doing live stream so that the courtroom will be open to the public. But COVID is real, so everyone still make sure you socially distance. And if you want to wear a mask, the court is okay with you wearing your mask. I saw people were doing their spring break. Nobody's abiding by any guidelines, but we're going to abide by guidelines and hear as much as possible. Any cases that are on the docket today that are scheduled for jury trial tomorrow, the court does have plea deadline dates. However, if a new offer was made to you, then the court will be open to accepting that plea. However, if your case doesn't work out, we're starting a jury trial tomorrow, and that jury trial will start at exactly at 9 a.m. So you'll need to be in the court at 9 a.m. for a jury selection. As I call your name, please let me know that you are here. Zachary Prince.
Your Honor, he is driving in from out of town and texted me that he's having traffic issues when he's on the road.
Thank you. James Cole. Adam Baez. Edna Salaba.
We're here, Your Honor, and we're ready.
Thank you. And I'm still working on the pronunciation of the last name.
Salaba.
Okay.
Thank you.
James Madrone. James Madrone. Johnny Tejeda.
Good morning, Judge. He's present.
Thank you. Lamont Curry. Lamont Curry. Wardell Lemon.
Judge, I spoke to him a few minutes ago. He was stuck in traffic, but he was just parking, so he should be up in a couple minutes.
Wilson Dyer,
I'm here, y'all.
Desiree De La Fuente,
Good morning, Your Honor. She should be on her way with the power outage and the rain. She should be coming through that door shortly.
there's been a power outage.
Yes, Your Honor.
Monique Rowley. Monique Rowley.
She's incarcerated, Judge.
All right, thank you. John Perez. John Anthony Perez, jail.
Yes.
Hanan Gandara. Hanan Gandara. Lillian Barrios Contreras. Lillian Barrios Contreras. Jaime Soto. Erica Morales. Manuel Rodriguez.
Present counsel, Your Honor.
Jesus Resendez.
Present counsel, Your Honor.
Ruth Trevino. Ruth Trevino. Ricardo Martinez, jail.
Yes.
Albino Flores.
Here. Present, Judge.
Anthony Villarreal. Anthony Villarreal. Roland Huerta. Roland Huerta. Juan Garcia Sanchez.
Present.
Obed Uridalis.
Present.
Thank you. This is my first time seeing you in person.
Yes, ma'am.
Joseph Harris. Joseph Dale Harris.
In jail, Judge.
Okay, thank you. All right, is there anyone here whose name was not called? All right, everyone confer.
I had a client set this morning. Maybe I put it on the wrong date.
Oh, this should be fine.
Gavino Vara, VARA is the last name,
Can you look that up on the system for me? Thank you.
and he was running late. But I spoke to him at 7:40
It isn't my fault, but
this morning. He said, "I'm on my way."
I'm the only representative.
So he's here. Look at that. He wasn't late. He was here.
Oh, you may want to tell him to sit.
Oh, no, stay back there. I'm sorry, sir. He was getting very excited, Judge.
That's okay.
I looked them up and I don't know.
Can you find- Is there any way you can grab the file? Let me see. if something-
I can give you if you give me a second. I've got my file right here.
All right, we'll see if I read something in the file.
No problem, Judge.
One thing you know about it, that's fucked up.
Yeah, that should be done. It's,
Yeah, it's like a-
I give you a case number.
Yeah.
Case number is 2019-11408.
Oh, God.
That's all right. I don't.
Gavino, did I say Gavino, sorry. That's fine.
I don't know where it got placed after that.
Yes, I got you.
Yeah, let me go pull the file.
No.
Still not a day show? Okay.
It shows February 22nd was the last day. Let me go.
Okay. I may have been one of those things. I just put it in my calendar. I told him to be here, Judge. Better be here than not.
Yes.
But may I run to announce in a couple of courts? I'll be right back, Judge.
Yes.
Thank you, Your Honor. I love your pen, by the way.
Oh, thank you.
I'll look at it. I don't.
Yes.
I ran out right before docket. I'm on Zoom as well in jail court. I'm here on Miss Crystal Martinez. Does sound like me and the CLO do have an agreement, but once state gets here, we'll just make sure that we have an agreed recommendation there and we'll.
Oh, thank you.
Yeah, I think I looked at it and signed like a previous offer. Right. That obviously doesn't.
Right, no, there was.
Yeah, so I think it over today.
Okay. Good morning, Judge. How are you doing?
Good morning. How's it going?
Good.
Recognize who that is.
I know.
I tried.
Sorry.
It's one
Like, I didn't even realize it until like 5:30 last night.
No, I really don't.
And Judge, Mr. Lemon just walked in. He's here.
I mean, I know which one is. I'm sure you've seen it all right. Yeah, like. No.
Okay, you can't. Good morning, how are you? Maybe I know. Yeah.
These are photos.
I think it's our first one, so.
Right.
I'm almost like 99% certain that. Some of these are like, it's not interview. Did not use photos as that is.
Morning.
Sorry, I was running late coming in. This I printed, but I printed front and back. Is that a problem? Do you want me to take it apart? It's the plea packet for Wilson Dyer and the discovery.
No, that's fine. Save the trees.
Exactly. You probably already got it, but I just printed it out. With the rain, we'll be able to do a little
Tried to, like, every time I tried to add it, it won't let me pronounce it. Well, it's just the names on this one, but it would let me add the 186. Oh, yeah, it's ready to take a slide. I'm gonna try to put on that.
Okay, I have someone for family violence, please. Someone from family violence.
Yes.
I signed the order that you both agreed to on this piece.
Okay.
Make sure that the complainant is aware.
Okay, yeah, she is. We
Oh.
reached out, yeah. So she's fine. Yeah, it's what she wants. Okay, do you need anything? You just
No,
want to
no,
confirm?
I just wanted to make sure that she.
Okay, yeah, she does.
God. That's the COVID.
Watch this.
He's the person.
Thank you. Yes.
I was in County Court 5, Your Honor. I have Christian Vernell, I believe in custody. Vernell, Vernel. Excuse me? I talked to his mom last night and said he was still in custody, so. It's an MTR.
All right, thank you. Oh, he's in custody,
Yes.
so they'll be bringing him.
Okay.
All right, thank you.
We have a call right
Okay.
All right. Question on this one.
Unless you want to go ahead.
Yeah.
Pettis on. John Pettis.
Morning, Judge.
Morning.
How are you today? I have Mr. James Cole. He is not here. I sent him notice when I got notice on Friday to him in person. He's in Washington State driving a truck. He is headed south, literally as we speak. Understanding that he needs to be here this morning. We are this close to a plea bargain on his case. He picked up a new charge. So it kind of complicated our negotiations a tad. Is there any way I could have him recalled for any day this week, or if the court wishes to proceed another way, let me know and I will let him know. Is he tomorrow? Okay. Yeah, I've told him get your butt here. So I wanted to check in and let you know. So we'll be recalled for tomorrow morning, Your Honor, at 9 a.m. Okay. All right. Do you know how far down we are on the list? Or no? Okay, you taking oldest first? I'm just trying to plan as far as in the event it falls apart on you.
No, we're not taking all this first. It's just.
I got you. Hard balls. Love your pen. It's still. I like that. I was reading yesterday. Okay, so I'm looking late on my iPad last night. It says 10 fashion styles that are outdated and will make you be old. I'm like, okay, I'm gonna see how many of these I get. And one of them was wearing pins, and I'm like, oh no. They got that one wrong, right?
They did.
The poofy hair, I kind of got, and the heavy eyeliner, I kind of got that. But the pins was like, no. They're classic forever, right? No, it was on the list, but I like that. So I'm glad I'm not the only one. So I will see you tomorrow, Judge. Yeah, it is what it is.
All right.
All right, thank you, Judge.
Sure. And the 31st is Dr. Jerry Johnson. All right, could I have the files on John Pettis?
That's for Extension of child custody. There's no contact outside of. Child custody. Offensive or related to child custody. I mean, because that would be technically child custody. Most of them are that exclude, because you know, it's language as it relates to. She was on the call.
Well, Clayton and I have this goal of trying to do 4 or 5 days a year, and that was before kids. And we haven't, I actually have one.
Me too.
One, Mother's Day weekend. after our pretty one. No, I mean, too much information, but like I haven't done this. Yeah, yeah, and I'm just.
So I pick signs and I keep getting the sign to the offside. So it's good sign of the book. All right, thanks.
I mean, maybe even call
Good morning. 2022, Saturday, Flores. Just wanted to see the bond violation. that they
Like just Tony, we have 5 rooms. So are you still talking to him?
Thank you, Ron.
Y'all are ready or not? Okay, just let me know when you're ready. Okay, cool.
It's not a temperature difference. Oh, 226.
Eric Apollo.
Does you want me to talk to Norma on my case?
Yes, what is happening with this here?
We've nothing right now, Judge. It is as far as our last time we spoke, it is a setting for a trial. He is on bond. It was Nisbet, so now it's I think Ryan gave it to Mr. Hunter. Mr. Hunter? No. Let me see, Judge. There's been such a mix-up. I can tell you exactly who it is. Just a second, because I was emailing them. Because I was trying to get them. Mr. Morris. No, I'm sorry, he moved. That's right. So it was. Yeah, it seemed that Hunter Morris was the person I was talking to, and Mr. Groomer as well. Mr. Morris? I will, Judge. And what I may ask for, Judge, is at some point, non-evidentiary, quick pre-trial motion hearing just to get my stuff signed.
All right, so everyone, excuse me, COVID is real. So could everyone not crowd into the well of the court? If you can make sure that you form an orderly line, not crowd around people. Nobody wants to get COVID. I don't want to get COVID. I don't want anyone in here to end up getting COVID. So if you're not conferring with the prosecutor, because I know some people are waiting in line to speak with prosecutors, if you could just wait and not crowd them and not crowd the well, that would be greatly appreciated.
So I'll get together with him. I forwarded him my motions just for potential 1107 writ kind of things later on. I'd like to have everything signed. Okay, so I'll approach him on that, Judge.
So Norma and Eric Apollo, when are we bringing him back? So what date? Just a moment. And then your client, Mr. Brown.
He's in quarantine.
Yes, you need to get a reset date.
He's in quarantine, they said.
Yes, he does. You need to get a reset date.
Okay, thank you.
Number, when are we bringing back Mr. Bernal? All right, April 4th.
Thank you.
Approach, Judge. Just one moment. Yes, Mr. Montgomery? Yes. Yes.
Thank you, Judge.
Yes.
I've got Jesus Resendez. It's an MTR. It's gonna be an open plea of truth.
Okay.
And we need to have one witness who's a Spanish speaker, so we have to ask for a translator.
Okay, thank you.
I have my nephew here who's interested in law school, so if that's okay for me to listen to you.
We will bathe in fire today.
Right, I'm trying to show him that this is not what you want. It's like, dude, I want something exciting. It's like, excitement is overrated sometimes.
But anytime he wants to stop by, we'll always have a phone call, scheduled to bar, so if he wants to come by.
Okay.
He's always more than welcome to see you.
All right.
Friday or everything.
Well, he's gonna go up, we're gonna have a Travis County hearing tomorrow. He's gonna go up and see what Travis County is like, but we'll definitely take you up on that.
Sure.
So,
All right, well, we'll be in trouble all week.
all right, thank you.
Okay.
And Norma, Monique Riley is in custody. It shows our bond of the docket. Yeah. All right, so what day are we bringing her back?
Can I keep this? You're like, you know, that's physics last year.
Judge, we're ready on our plea. I have to go down to the 227th, but would you rather me stay here and get it done?
Your time has already been sworn in. We'll take it up.
Okay, he's gonna do it right now.
Norma, what is happening with Lamont Cody?
Lori. Lori, can you bring your class? Yes. Thank you.
On what code? Probably going to recall this beforehand because there's a new case. Yes. But this is brand new. So we call it beforehand. Who discussed it with Marcus? I think that's gonna need to be called before.
Yes, that's the one he wants to go on.
Oh, so he's aware of the new one?
Yeah.
He wants to go on.
He wants to bench trial on that.
Okay,
Yeah.
all right, thanks.
May we approach?
Yes.
Morning, Judge.
Sorry.
That's
Well,
okay.
we can
Surprise.
take a few steps back and do it
Yes.
again. We have Wardell Lemon. I think he's pretty high up in the lineup. I filed states, as far as I know, first motion for continuance, and I provided it to defense. I let Mr. Navy know last week that we may be doing that in this case. I have my copy here if the court would want to see it. And we're urging that motion.
Is Mr. Lemon here?
He is. He's with the blue tie and the glasses.
Are you ready with your motion?
I'm ready, Judge.
All right, just grab the file from the case.
Okay. Okay. Oh, is this the, it has an arrow, it makes it look like go up there.
Yeah, it's like COVID is real. COVID is real.
Resendez? Resendez? Is Resendez?
Go grab it.
Okay, thank
It just depends, yeah. I mean. Yeah, yeah, and obviously that changes things. I feel like most of those cases. Yeah, like right now, we made the lineup. I mean, I think it's just like. No, yeah, we're just.
All right. Brenda, are you ready?
Yes.
All right, if everyone can please be quiet, please. Put Mr. Lemon come up.
Yes. Come on.
All right, the court is calling 2020 CR 7353, State of Texas versus Wardell Lemon. That party is announced for the record for the state,
Michelle Hayden for the state.
for the defense.
Nathaniel Navy, Your Honor.
All right, this is scheduled for a jury trial, actually for tomorrow, March 22nd. And for the record, is your client, Mr. Lemon, and is this Mr. Lemon?
Yes, Judge, this is him.
All right, defense, are you ready to proceed with jury trial tomorrow?
Judge, we're ready.
All right, state, we filed a motion for continuance.
We did, Your Honor. We're asking for a continuance in this case. What we're actually hoping for is that the case could be set maybe sometime in April with enough advance notice, make the case the priority that day. I know we don't do special settings, but just to allow all our witnesses to accommodate their schedules, since the vast majority of them have to travel from out of county. As is stated in our motion, Harris County Sheriff Deputy Joshua Gabriel has a newborn infant. He's got doctor's appointments scheduled this week. The forensic interviewer in this case started a new position, does not have leave time. Dr. Rena Isaac does not have childcare for the week of March 22nd. She's the one that met with the victim in this case. And then the father of the victim, Justin Keeney, who's also a witness in this case, has a trip scheduled to Houston for this week.
All right, defense,
Judge, we're ready.
do you object?
I would, Judge.
All right, this case has been pending since July 2020. So the first setting for this case was December 14th, 2020. Then it was recalled for February 1st, 2021 for discovery issues. Then it was recalled for March 4th for discovery issues. And then it was recalled for April 1st because there were flooding issues in the district attorney's office. Which is a side note, there were flooding issues in this court as well, but no carpet has been replaced. And my court coroner may or may not end up getting mold because the county does not want to place the carpet in her offices, even though they promised to do so. April 1st, then all discovery was received. It was recalled on April 9th for a plea deadline date and an acknowledgement of discovery. The plea deadline date was then scheduled for May 13th. The defendant requested a jury trial, so it was reset for May 28th. Then COVID shut down, so then it was reset for August 23rd, 2021 for a jury trial. Then there were COVID issues, again, jury trial suspended. So the court extended the plea deadline date and the offer was rejected. And we came back on April 4th, 2021, and then it was reset for December 2nd. Defendant wanted a jury trial, again, COVID issues. Then on December 2nd, 2021, there was additional discovery that was given. And because of that additional discovery, the court extended the plea deadline date. Then we came back on December 13th. And then on December 13th, the plea deadline date had expired. The defendant rejected that offer. Then we came back on February 22nd, just to make sure all discovery was entered. The offer was tendered, offer was rejected, and there was a jury trial date scheduled for today. So state, have any of these witnesses been subpoenaed?
Judge, they've been contacted, but they're not under subpoena right now.
All right. State's motion for continuance is denied.
Thank you, Judge.
And we'll see you tomorrow.
Tomorrow. Okay.
No, Mr. Lemon is coming back tomorrow. Brenda, which page is Mr. Lemon on?
He's on 10 at the very bottom.
Thank you. All right, who are the parties on Edna Salaba? And can I have someone from the state, please?
Mr. Villarreal.
All right, court is calling 2020 CR 1024, State of Texas versus Edna Salaba.
Michelle Hayden for the state.
Michael Villarreal for the state.
For the defense.
Lorraine Efren for Ms. Villalba.
And are you Edna Salaba?
Yes.
All right, Ms. Salaba, I'm going to show you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, sir.
Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Ms. Salaba, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state's proceeding on the lesser included offense of assault causing bodily injury, and just for purposes of the record, we wanted to make it clear that we are not proceeding on any type of family violence or familial relationship allegations.
Any objections?
No, Your Honor.
Ms. Salaba, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did. We
Off the
actually
record.
signed in person.
Thank you. Off the record for just a moment. The interpreter's here. All right, we're back on the record. I'm still used to saying sign.
I know. Me too.
Did you understand that document? Did you review it with your attorney and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor? The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Just one moment off the record. Do y'all want to remove this? Yes.
If we just put it on there, I don't know. We can, they're not numbered, are they?
No. But I mean, it can stay there because she actually, it doesn't apply to her, so
Yeah.
it can stay there.
Okay.
Yeah,
Gotcha.
that's what I told her. to
Yeah.
do.
All right, we're back on the record. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court would find you guilty, not grant you community supervision and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, yes, Your Honor.
Miss Lava, I'm sorry, I keep mispronouncing your name. I'm working on it. Lava. Did you, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived their right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault bodily injury. There's a $750 fine. The state recommends deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None ruled upon, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be 80 hours of community service restitution. No contact with Christian Villalaba outside of civil orders relating to child custody exchange, school conservatorship, and child emergencies. And also the hostility and aggression control course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense of assault bodily injury, how do you plead? Guilty, not guilty, or no contest?
No, no contest.
State, any evidence to support the defendant's plea?
Yes, Your Honor. At this time, state offers state's exhibit number 1 and its attachments.
No objection, Your Honor.
I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we're just asking for the court to follow the plea agreement. We believe that this plea agreement is in the best interest, not only my client, but the children. And so we're asking the court to follow it.
So how are things now between the relationship with her and the father of the children?
They're much improved. So the offense dates here occurred during a very contentious divorce. And that divorce concluded in an agreed decree in like June of 2019 or May of 2019. And at which time they agreed to a 50-50 conservatorship, joint managing conservatorship. And they've struck a balance and a peace since then that's been working. So we feel like by entering this plea probably spares the whole family a lot of tension, and she's hopeful that that peace will continue. It's not love and parties, but they have been successfully exchanging the children and enjoying a 50-50 arrangement that's been workable. And the children are 9 and 6 now, and they're in school, and it all seems to be working well.
Are you currently employed?
No.
Right, so how are you supporting yourself?
My boyfriend supports us.
She's in a long-term relationship, and she's been able to stay at home during COVID. And
what are the ages of the children in the household?
9 and 6. And the 6-year-old has some health issues, I think, that are under control now, but were at a time very significant. COVID made it, of course, made it difficult because she was home with them for virtually 2 years.
Did you complete parenting classes as a part of the custody agreement or not?
No, we never were asked to do that.
I would ask the court to hold that in abeyance if you're thinking about doing it. I feel like they've been co-parenting successfully. And if you saw this divorce file, it was one of the biggest ones I've seen a lot. It was very contentious.
All right, is there anything else you wish to say?
No, Your Honor.
All right, this is what the court is going to do. $750 fine that'll be probated, 1 year deferred adjudication, 80 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. That includes the booster. The court is not ordering anyone to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be no contact with Christian, and that's Christian Villalaba, outside of civil orders, custody exchange, I guess school activities, conservatorship, and child emergencies. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider with minors. You must complete parenting classes. If you complete those parenting classes, then the remainder of your community service hours will be waived, but you must complete parenting classes. And there's to be regular reporting by Zoom or in person, and there's to be regular UAs. Is there anything else from either side with regards to sentencing?
Nothing from the state, Your Honor.
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes. All right, we can go off the record. Miss Villalaba, you're being given parenting classes, and let me tell you why. Because I realized that it was a contentious divorce. I've read through the paperwork, but adults need to understand when you have a contentious divorce and you have children, guess what? The children are impacted and affected by it. So that whole thing that happened in the driveway, your child was affected by that, okay? So that's why you're being given parenting classes, because parents need to realize that everything that you do in your life, intentionally or unintentionally, impacts the child's well-being, okay?
Yes.
All right, good luck to you. Probation is going to speak with you.
Thank you, Judge. May I be excused?
Yes. So if you'll wait, and probation will speak with you. And you're excused. Yes.
Can I approach briefly, Ron? This Honor Ricardo Martinez, which is looking to get a bond set. I could walk you through the different
Have
steps.
you
of it.
conferred with the state?
I have. It's an MTR. So if I could, Judge,
Okay.
I was appointed on the 13th.
Okay, so everybody needs to stand back on the thing because
Oh, I didn't know.
COVID is real.
My
COVID is
apologies.
real. I keep telling people COVID is real. So is this on the docket for today?
Yes, Your Honor.
All right.
It's an MTR.
So what is, and your client is in custody?
Affirmative, Your Honor.
All right, what is happening with the motion to revoke?
We're going to ask for a contested hearing, Judge. My client wishes to retain an attorney. I was appointed on the 13th. I tried to do a jail visits with him on the 14th and 18th, and both of them he missed because there are miscommunication issues. So I met him for the first time this morning. He indicated he does have an attorney who he's hired on previous occasions, and he wishes to hire that attorney again. He wishes for a bond to be set. It's his first case ever.
It's his first conviction. There were other cases that were taken in consideration at the time of this plea, Judge.
It's a deferred adjudication, and it's his first setting for an MTR. So we're asking for a bond to be set, for a contested hearing to give us more time to get to that. I don't know if it'll be
So who's
contested.
he hiring? Is he hiring you?
No, Your Honor. He's hiring Ray Orton.
All right, so let's have Mr. Ricardo Rocky Martinez Jr. Come on.
Sorry, there's a lot of preliminary before we get to the actual.
No problem.
Yes, Your Honor.
Yes, when are you gonna have this attorney hired?
I already talked to him.
All right, so when will that be?
By today.
I'm sorry?
By today.
All right, so Ms. Ferguson, let's recall this later in the week and we'll hear you, the bond motion with your new attorney. And then if that attorney is not hired, then Mr. Froelich will be your attorney and he will be here to hear the bond motion and whatever else that needs to be done on the motion to revoke.
Judge, it is a deferred. Can we have a bond set today? We would ask the bond to be set
But
today.
he's saying that he's already hired an attorney.
Well, I mean, I didn't hire him. I talked to him. He's supposed to be already getting hold of me.
So he has not retained an attorney at this time. He is actively in the process of it. He has given me the phone number. I have contacted his, I think it's his girlfriend. His girlfriend, who's going to contact that attorney today. Again, this is the first time I met Mr. Martinez this morning because of communication issues with the jail. I've been appointed in the case for less than a week.
All right.
So we've asked for the time and the bond to be set.
So is this attorney being hired today?
Trying. I'm gonna try.
All right, have you all agreed on a bond?
We haven't, Judge. If you can give me or can you just tell me what the bond was on the underlying case, Judge?
$1,500, it was $1,500.
Judge, based on the allegations we have here, we have one new misdemeanor case and a alleged possession or testing positive for methamphetamine. We'd ask for a $10,000 bond.
All right, and state, do you have a motion? I'm sorry, defense, do you have a motion?
Just a motion to set bond, Your Honor. No, I have not filed one. However, I asked the court to set a
All right,
$3,000.
state, before we go on the record, are you okay with proceeding by an oral motion?
Yes, Judge.
All right, the court is gonna call 2020 CR 5069, state of Texas versus Ricardo Rocky Martinez. Can I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Andrew Fraley for the defense.
And are you Mr. Martinez?
Yes, ma'am.
All right, defense?
Judge, we'd ask for a bond to be set in this case for the motion to revoke. We asked the bond be low enough to where he could make it. We'd ask for a $3,000 bond.
Judge, the state would ask for a $10,000 bond in this case. Mr. Martinez is on a motion to adjudicate probation on a deferred. He has picked up a new misdemeanor case, and one of the allegations is testing positive for methamphetamine. We'd ask for a $10,000 bond.
All right. Your bond will be set at $8,000, full GPS. Court will waive the GPS fees. Ms. Ferguson, can I have a contested hearing date, please? Can we do it sooner than that? I'm not taking Mr. Martinez, I'm not taking any of these allegations to be true. But the allegations appear to be you not reporting ever, maybe. A positive UA. And not submitting for drug testing.
Judge, just to be clear, he did report for a number of months while on probation, but then.
I was even doing classes too.
Oh, well, no, here's the thing.
Yeah.
I'm not taking any of it as true. I'm just telling you what's in the violation report. So Ms. Ferguson, when is that going to be set? April 14th. All right, so we're going to come back on April 14th for a contested hearing. And your attorney, whomever you hire, needs to be ready for a contested hearing on April 14th. What time, Ms. Ferguson? At 2 o'clock. At 2 p.m. All right, is there anything else?
Not from the state, Your Honor.
Judge,
Yes.
we would ask for a partial GPS, Judge. He does have a job, construction job. He has to be working during that time.
All right, he needs to bring proof of that, and then the court will consider it, of course. All right, if there's nothing else, you need to speak with probation or anyone else.
There you go.
All right, thank you.
Thank you.
Excuse. And everyone, just give me a moment. I'm going to take up a matter that is with an interpreter. Thank you. All right, who's the person, who's the? All right, thank you. How are you? How's it going? Okay, nobody leave, just give me 2 seconds. I say 20 seconds, just a moment. I just need to correct one item.
I'm good. How are you? It's a big, forget how you do it.
After finish. Show respect.
Oh, I know. Yeah.
No.
I guess, yeah. I did too. 2-year break.
Okay, everyone. COVID is real. Please don't stand so close to the interpreter. Everyone, please push back. Thank you.
My client speaks English. It's a witness, Your Honor. That we
Okay.
translate.
Awesome, thank you. All right, the court is calling 2019 CR 0687 State of Texas versus Jesus Resendez. Can I have parties announced for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
Tilden Schaefer for Mr. Resendez, Your Honor.
And are you Jesus Resendez?
Yes, ma'am.
All right, Mr. Resendez, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jesus Resendez Jr. who was placed on deferred adjudication in 2019 CR 0687 for the offense of aggravated assault, serious bodily injury on August 15, 2019, for a period of 8 years. Is that you?
Yes, ma'am. That's
All right, state.
Yes, Judge. Violated condition number 2, on or about the 18th day of February 2020 in Bexar County, Texas. The defendant, Jesus Resendez Jr., did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Also violated condition number 2, on or about the 19th day of March 2020 in Bexar County, Texas. The defendant, Jesus Resendez Jr., did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
For purposes of the MTR, Judge, we'd waive the remaining conditions.
No objection.
All right, Mr. Resendez, did you understand by pleading true to violations of 2, 2, and 2, the court can find you true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, sir.
Knowing that, do you still wish to plead true to violations 2, 2, and 2?
Yes, ma'am.
Court will find violations 2, 2, and 2 true.
Yes, Judge. Oh, sorry.
Oh, no, go ahead.
Judge, we don't have an agreement in this one. The state would be asking for the court to deny the motion to enter an adjudication of guilt on Mr. Resendez. We would, however, ask you to alter and amend to add the condition of Bexar County ISF for 180 days. Judge, this is also the recommendation of probation. Mr. Resendez absconded for approximately a year. In addition, he failed to provide drug tests, which were the violations which I read to the court, and he was unsuccessfully discharged from a couple of his classes. We believe that the Bexar County ISF program would be appropriate to get him to take his probation a little bit more seriously in terms of what the court is asking him to do. However, the defense may be asking for a different outcome.
All right, defense.
Your Honor, prosecution is correct. We are asking for outpatient treatment. I know that's what he had originally, and he messed it up. He just didn't do it. He hired me in December, and we've been talking since then. He's very nervous, and it took me a little while to get him to come on in, make the bond, which you set for him. And he's a different man now because he is no longer drinking alcohol. If you look at his record, it's alcohol. This was an assault where he broke an arm of a friend. And back in those days, he was drinking alcohol, and he now no longer drinks, which is a huge change for him. He's a pretty mild-mannered guy, but he's really big and strong. And so when he was drinking, he just became this different person. I'm not sure what happened, but I know it was the summer of 2020, and he may have probably took some advantage of you could see where he's got these number 2s. And I think probation was giving him chances. They weren't revoking in the spring. But then he stopped the program, and then he got kicked out of his outpatient in the summer of 2020. And then he just flat out stopped reporting. It's been about a year and a half, but he came in, he hired me. He wanted to make things right. He wanted to stop worrying about somebody arresting him. And he wanted to prove to the court that he's no longer this person. He recognizes his issue, and his issue is alcohol. And just makes him a very different person. I do have a friend here who's known him. They work together, and her name is Candace Jebka, and that's spelled, it's a Polish name. It's spelled R-Z-E-P-K-A. And I would call her briefly as a witness, Your Honor.
Oh, thank you. And what is your language?
Polish, but no, well, it's Polish name, but she speaks Spanish.
Oh, okay. I
No,
thought I was
I don't
trying
do
to
Polish.
get
I can't
something
speak. That's beyond my wheelhouse.
Hello.
Judge.
Hello. All right, great. We have an interpreter. If you could raise your hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God?
I do, Your Honor.
All right, thank you. And if you could state your name for the record, please.
Carmen Tarragona Saiz.
All right. Defense, you have a witness?
Yes.
If you could call your witness.
I call Candace Jepka.
Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear to God.
All right, if you could state your name for the record, please.
Candace Julieta Jepka.
Candace Julieta Jepka.
Defense?
So, Ms. Jepka, how do you know Jesus Resendez?
Trabajamos juntos
We worked together
hace 3 años por primera vez
for the first time 3 years ago
en el Riverwalk.
at the Riverwalk.
Do you still work together?
Sí,
Yes.
pero en otro restaurante.
Yes, but in another restaurant.
And were you aware 3 years ago that Jesus had a drinking problem?
Sí.
Yes.
Did you ever see him when he was drunk?
No.
Okay, so how did you become aware of this problem?
Por amigos que me lo comentaron
Through friends that mentioned it to me.
y él mismo me lo ha comentado.
And he himself told me.
And did y'all have an opportunity to discuss that and talk about it?
Sí.
Yes.
And so what would you tell them? What were y'all talking about?
Pues yo siempre le aconsejé que dejara el alcohol porque es era su principal motivo por el cual él se buscaba problemas.
Well, I always advised him to not drink because that was the main cause of all his problems.
And so, do you know if he's still drinking alcohol?
Ya no consume desde hace 6 meses.
He has not consumed alcohol since 6 months ago.
And has he talked about how this has changed his situation?
Yo me he dado cuenta que ha cambiado mucho.
I have noticed that he has changed a lot.
Now, as far as when he's working, is there anything, has he ever had any trouble while he's working?
Nunca.
Never.
Trabaja muy bien,
He's a great worker,
muy responsable,
very responsible.
tiene muy buena relación con todos en el trabajo.
He has a great relationship with everyone at work.
Con los clientes es muy atento.
He is very attentive and polite towards the clients.
And so, what assurances can you tell the judge about Jesus moving forward and staying away from alcohol? What can you tell the judge?
Ha cambiado realmente mucho y sí le veo las ganas de superarse.
That he has truly changed a lot, and I do see a willingness to move forward and get better.
All right, pass the witness.
The state has no questions for this witness. Your Honor.
Thank you for coming. Thank you. And do you need the interpreter? All right, thank you so much for coming. Yes.
Thank you.
All right, any other witnesses?
No other witnesses, just my client. So you are a witness in a sense. So I'd call my client.
All right, if you can raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am. I do.
All right, you can lower your hand if you can state your name for the record, please.
My name is Jesus Resendez, Jr.
So Jesus, a little nervous today?
I'm very nervous.
Okay. Well, you know that the judge has the power to put you, you heard,
Yes, sir.
prison up to 20 years,
Yes, sir.
based on what's happened. And that probation and the state want to put you in inpatient treatment.
Yes, sir.
Okay. So can you tell the judge why it is that, what was your motivation for getting off alcohol?
Getting alcohol, I don't want to be walking around life with something in my back. I want to do better. My parents recently moved 4 years ago to from San Antonio to El Paso. They're the reason I'm here, but they left. I want to bring them back. I just want to better myself in every single way. Like this whole year that I was on the run, I guess. It's a horrible feeling. I don't want to ever go through that again. Just an ugly feeling that I have like somebody out to get me, and I just want to do better.
So fair to say, if we look at all the allegations in the motion, you really didn't do a good job, right? Okay, so what can you tell this judge about why you're going to do a better job now?
I'm not drinking. Of course, I like to consider myself different.
So what brought you to recognize that you got to stop drinking?
That's true. Health, my family, my friends, the way I was affecting my relationship.
And so, and what can you tell this judge about your ability now to do this outpatient and not go into an inpatient? How can you, what are you going to tell the judge as to how it's going to work this time?
It's going to work. I have better support system. I have better mentality.
So what is your support system?
Good friends.
So Candace and your partner, and he's here today, isn't he?
Yes, sir.
Okay. And he's come into the office, the three of us have talked.
Yes, sir.
And so since you've hired me back in December, we've had a number of appointments in my office where we've talked about your situation. Haven't we?
Yes, sir.
Okay. And so what are you asking this court? Are you asking this court to allow you to do the inpatient versus, the outpatient versus the inpatient?
Yes, sir.
Pass the, he's gonna ask you some questions.
State.
Mr. Resendez, when did you say you stopped drinking?
About 6 months ago, October, September 3rd.
Why did it take so long after you stopped drinking to turn yourself in on this case?
To be honest, it was nervousness. I didn't know what process to do. I hired him, and he's guided me really good.
You've been told by your attorney you face up to 20 years in prison on this case, right? Okay. How can you reassure the judge that you won't get nervous again?
I don't know, nervous and what.
You said that the reason you didn't turn yourself in was because you were nervous.
Yes, sir. Well, I was nervous to do time in jail because my parents are older. They're in their 70s. My mom has dialysis, so I was afraid that she would pass away there. It's just little things like that bug me in the head sometimes.
Who controls whether you're going to do time in jail in this case, Mr. Resendez? No further questions, Jack.
Any other questions?
No, you're not.
Mr. Resendez, if you're drug tested today, I know you're going to get drug tested today. What are the results going to be?
For alcohol, clean.
Yeah, I mean, everything.
For everything, I'm not sure.
So what else is out there?
Just marijuana.
I'm sorry, what?
Just marijuana.
When's the last time you used marijuana?
About a month ago, less month, around. About a month ago.
So why are you using drugs? So it appears that you just exchanged
Yes, ma'am.
alcohol for marijuana.
No. It's not nothing like that. I'm not using it to party or nothing like that. I'm not.
So why are you using it?
Why? I don't know.
Here's the thing, I understand what people think about marijuana, but marijuana, possession of it is still a crime. If you're using it while you're on probation, that's a violation of your probation. So other than marijuana, what else?
That's it.
All right, so why are you using marijuana?
Stress, I don't know. To be honest, there's no good excuse.
It appears your client has been using marijuana.
Yes, Judge.
You want to address those issues?
Well, I think that, he's one of my more nervous, anxious clients. And I don't know if this is kind of a self-medication thing, but that's part of what we've been talking about is the need to get off all this stuff and to get into a program and rely on that support system that he has. And not use the marijuana.
All right, is there anything else from either side?
No.
Judge, just from the state, we believe with the new revelation of the drug use, or at least the marijuana use, that ISF would help his decision-making. It sounds like he does have those nerves in this situation, that he doesn't always make the decision based on what he should do, but based on what his body's feeling, and we think that ISF may help him with those abilities.
All right, and probation, what is the wait time for ISF?
I believe total of 10 weeks with medical screening and to get into the program.
All right, this is what the court is going to do. Deny the motion, alternate main conditions to include the UA hotline. If he misses the UA hotline anytime, then he's going into custody, he's going to ISF. I want him tested for levels. If the levels rise, then he's going to ISF. And I'm going to want field visits, random 2 times per month. And there's to be weekly Zoom reporting or in person. And I'm going to want a UA today. By 1:30 p.m. And if he's positive for anything other than marijuana, then he's going to ISF. So is there anything other than marijuana that the court should know about?
No.
And that includes alcohol as well.
No.
So if he tests positive for anything other than marijuana, if it's alcohol, if it's meth, if it's something else, then he's to go into custody, he's going to ISF.
Can I ask him a question?
Yes.
Do you have allergies or any kind of medication in the last couple of days for allergies, anything like that? All right, well, don't start taking that stuff right now. That can be a problem. That's all right.
Is
Thank
there
you very
anything
much.
else? All right, you need to remain in court to go over conditions with probation.
Yes, ma'am. Thank you.
All right, Mr. Resendez, here's the thing. From here on out, everything that you do in your life, you should ask yourself whether or not that could potentially result in you going to prison for 20 years. You understand?
Yes, ma'am.
All right, just remain in the courtroom and probation will go over conditions with you.
Thank you so much.
You're welcome.
Thank you.
All right, who are the parties on Desiree De La Fuente?
Council's President, Your Honor, I'd like to approach with the state.
I can be extended.
What is going on?
Judge, this warrant came out, I think, early of this year. I just bonded it out and I need some time to get some discovery. We're asking for a reset, Judge. This is the first court sitting.
All right, and where's your client?
She's here. She's.
All right, Desiree De La Fuente. And what discovery, is there discovery missing?
Judge, I'll be honest, you were talking to Marcus, correct?
Right.
Okay, I can
We're
pass the
dealing with,
word on to Marcus.
yeah, we're dealing with almost police department, Your Honor. So I don't know what's going to be available, if they have anything available. But there's a question as far as the stop itself, the location.
On De La Fuente, I have to file. Can you give me a 30-day reset, please? All right, we're going to come back on April 26th.
Thank you, Your Honor.
All right, you and your client are excused, but make sure she receives a reset form before she goes.
Thank you.
You're welcome.
I have it right here.
Thank you, Judge.
All right, who are the parties on Obed Uridalis?
President, Your Honor.
Yes.
Do you want my client to come up, Judge?
Yes, this is for jury trial. Are you all ready for jury trial?
Judge, this is the one where I had approached, and we're just trying to move it 3 weeks. Marcus is okay with it. I spoke to him this morning.
Okay, so I'm sorry, you're moving it 3 weeks because.
So, Judge, I had spoken to Mr. Sanders about this. I have a co-counsel in this case, and her name's Haley Peace. She's leaving a civil law firm, and it's like her turnaround time for availability.
All right. Ms. Ferguson, on Mr. Obed Uridalis, can you recall this for jury trial in 3 weeks, please?
Yes, sir.
Thank you, Judge, for your time. I know you're busy today.
April 11th.
All right, April 11th.
That's perfect, Your Honor.
All right, thank you.
Yeah, I can do that, for sure. Let him know. Yeah, definitely. And would we be excused today?
Yes.
Okay, thank you,
Just
Judge.
get the reset.
Yes, ma'am.
Thank you. Renee, what page is that on?
He's on the recall.
All right, thank you. All right, who are the parties on Benjamin Williams? Defense and defendant Benjamin Williams. Benjamin Williams.
There's two others that are in the TIC.
Yeah, just go on.
All right, the court is going to call 2019 CR 12017, State of Texas versus Benjamin Williams. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Tony Ananda, on behalf of Mr. Williams.
And are you Benjamin David Williams?
Unfortunately, yes.
Well, I mean, not unfortunately. I mean, are you Benjamin David Williams?
Unfortunately, yes, ma'am.
What does that mean, unfortunately? Yes.
I hate to say it, but yes, I am.
Okay. I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Benjamin David Williams who was placed on community supervision in 2019 CR 12017 for the offense of assault family household member, previous conviction on March 6, 2020 for a term of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violation condition number 9, on or about the 15th day of April 2021 in Dyer County, Texas, the defendant Benjamin David Williams failed to report a change of address to the supervision officer within 48 hours in violation condition number 9.
How do you plead to that, true or not true?
True.
Violation condition number 15G, on or about the 23rd day of July 2021 in Dyer County, Texas, the defendant Benjamin David Williams did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or head of or authorized personnel of the following counseling or education program, state accredited battering intervention and prevention program, and violation condition number 15G.
How do you plead to that, true or not true?
True.
The state would waive and abandon all remaining allegations for purposes of this hearing.
Any objections to the state's waivers?
No, yeah.
Mr. Williams, that mask doesn't work unless it's over your nose. All right, did you understand by pleading true to violation 9 and 15G, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand?
Yes.
Knowing that, do you still wish to plead true to 9 and 15G?
Yes.
Court will find 9 and 15G true. Is there an agreement?
Yes, Your Honor. The agreement to grant the state's motion, reform the underlying sentence to assess punishment at 5 years confinement in the Texas Department of Criminal Justice. And the state will be taking into consideration clause numbers 2021 CR 7515 and 2021 CR 7518.
Is that the agreement?
It is, Your Honor.
Mr. Williams, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court will follow your agreement. As previously stated, the court is finding 9 and 15G true, 5 years in the prison, give you credit for any time served, taking consideration 2021 CR 7515, 2021 CR 7518, and there's affirmative finding of family violence. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Is there a reason you're staring down state?
Benjamin.
Williams.
Ben.
I'm unaware of it, Judge. I don't know why.
Benjamin.
Mr. Williams.
What's up?
What's up is that you're going to prison for 5 years. Did you see this trial court certification of defendant's rights to appeal? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal. You do not have the court's permission to appeal. Because this is a felony conviction, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over the definition of weapons or ammunition, you'll need to speak to your attorney. You can take him away.
Thank you. Judge, he did successfully complete ISF. I mean, yes, ISF.
It didn't work.
No, he will not receive credit for that. You're welcome. There should be no credit for ISF.
Okay, I don't.
All right, thank you. It is Monday, Brenda.
What was that all about?
But you know what? Even though it's raining outside, it's still gonna be a beautiful day. All right, and everyone, just so you know, I'm just calling you in order of when I receive the file. So I know some people are jumping up here that they're cutting in line, but I'm going by the way the files are given to me. All right, who is the person, Albino Flores?
Right here, Judge. Here you come.
Tony. If your client has a question over what a weapon or ammunition is, you need to contact me.
I'm pretty sure he knows what that would be, but this is actually a good day for him.
Okay, all right, thanks. All right, we're not on the record, Brenda, for this one. All right, we're here on a violation report, and this is the third violation report.
Yeah.
Okay, understood.
Have you ever conferred on this?
Yeah, I have, Judge.
conferred with female VA.
It was great, but I think I can say it, Judge.
All right, and this is not on the record. This is just a, well, I shouldn't say just, but this is a violation report, and I normally don't put those on the record. But this is his third violation report. Have you all had a chance to confer? Is there an agreement or not?
Well, there's a partial agreement. We had conferred and the state decided that, so my client, he works and he has a vehicle that belongs to a company that he drives for work. Sometimes, not all the time. He does have the interlock on his personal vehicle, but he doesn't really drive that. And so what they're alleging are he's not going to AA 3 times a week and that he's not blowing.
So why is he going to AA? Why are you not going to AA?
I just got that information earlier this month. I haven't got a chance to, it's only been about 2 or 3 weeks. I haven't got a chance to follow up or get any information. I heard you could do it online, Zoom, or there's different places, but I've just been busy with work.
All right, because they have AA meetings and NA meetings throughout the city at all times of the day and night. My understanding, you can find an AA meeting at 6 a.m. if you need it at 6 a.m. or 2 a.m.
Yeah, I just got that list myself.
So the court was unaware. State, I don't know if you were aware that he was driving without an ignition interlock.
Yeah, Judge, I think that's problematic. I think my understanding in hearing conferring with Alex is that we're asking for an ignition interlock to be put on his work truck. The reason for that would be obviously is the in-home device, it sends off a signal that something's going on, but the ignition interlock doesn't allow the vehicle to move if we have a violation. In this particular situation, it sounds like we have someone who's suspected of a driving while intoxicated offense who has a vehicle that he has been using without monitoring. So we would ask that the ignition interlock be put on that vehicle as well.
Our response, Judge, he doesn't own that vehicle, belongs to the company, and I think there's an exception.
What does he do?
He works construction, helping paint, flip houses, works in that business.
I mean, he's not going to be able to drive because the issue, Mr. Forrest, because usually I would allow people who have a work vehicle, I would allow them to just take the device with them. But you haven't been doing well at all. This is your third violation, which means that I probably had 2 other discussions with you before, because I always have discussions when there are violations. So what are you going to do other than drive your this work vehicle? 'Cause I don't know what else to do with you.
I was telling him I could do that mobile one with the handheld.
The in-home.
Yeah, the one you could blow like throughout the day. I said I'm just fine with that. I can use that.
in addition to the interlock on his vehicle. And I had told him, I don't think he was aware of this, that even if he's not driving it, he has to blow into it at least twice a day.
So state, would you want him to, as an alternative, are you okay with keeping the ignition interlock on his vehicle? But during his work hours, maybe he has to blow on the other one every 2 hours or every hour?
Judge, I'll defer to the court on that. I mean, if there's some type, I mean, like you said, it sounds like he's not only having issues with that, but some of the other stuff. If there's some type of enhanced, not surveillance, and enhanced monitoring that we can kind of do in that way, maybe more often blowing, just to make sure that he's not putting anyone at risk by getting behind the wheel of a vehicle that's not being monitored. Judge, I would also just, I think you've already done it, but I would just admonish him that at this point, this is a third pretrial violation. I don't think there should be a fourth pretrial violation at that point. Either the state or the court would be asking for his bond to be revoked.
All right, so Mr. Flores, the next violation, if there is a next violation, we're going to have a hearing on this, but that hearing is going to occur most likely after the court has already made its ruling. You understand? Which means these violation reports, the way they work, is I already have options to increase your bond without having you before me, but I don't like to do that. I like to find out what's going on in each case before I do that. So this is the third time that we're having this conversation. If there's another conversation, it's going to say that it's a fourth conversation with us. You understand?
Yes, ma'am.
So we're going to do 90 meetings in 90 days. You already know where and how to get your meetings. And you're going to start with a meeting today. Do you understand?
Yes.
With the portable alcohol monitoring, I'm going to have you blowing that every hour. You understand? While you're at work.
Now, with that being said, would I still have the one on the vehicle as well?
Yes. All right, and you're going to, that PAM device is going to be used at your work, and you're going to provide a work schedule with probation. Do you, I mean, with pretrial services, do you understand?
Yeah, I think I already do one time. I submit that. Yes. Yes.
All right, Ms. Ferguson on Flores, Albino Flores, do I have a 30-day reset, please? All right, we're going to come back on April 26th. And if there are any other violations, and you know, Fiesta is almost upon us, we can do Fiesta during COVID, but you should not be celebrating Fiesta. You understand? All right.
Thank you, Judge.
You're welcome.
Thank you.
You're welcome.
Thank you.
Gavino Vara.
Mr. Flores, something to be for everyone.
Judge, Mr. Bauer was set for the 13th for a motion setting.
Okay. All right, so motion setting is on the 13th.
Yes, Judge, and I've already conferred with Mr. Morris. He's gotten copies of everything. I think it's going to be all agreed to. It's non-evidentiary. We're just getting everything signed up. and ready to go.
All right, then just get a reset form. Ms. Ferguson on Gabino Vera. They're coming back on April 13th for motions, and you can set that in the daytime. They tell me they're agreed.
Thank you, Judge.
You're welcome.
Okay, I've got an MTR too, but I'll hold on.
Okay. Linda, what page is Mr. Flores on?
I don't see how.
All right, thanks.
Whenever you're ready, the compliance.
Okay, awesome. All right, who is Wilson Dyer? All right, the court is calling 2020 CR 8516, State of Texas versus Wilson Dyer. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Derek Emmis from Mr. Dyer.
And I'm Wilson Leland Dyer Jr.
All right, whoever's coughing, you're more than welcome to take that outside. And are you Mr. Dyer?
I am.
All right, defense, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Dyer, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
I did not.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on, I believe it's the lesser included offense under count 4, indecency with a child by exposure, and waiving the other counts.
Any objections?
No objections.
All right, Mr. Dyer, I'm going to show you what's entitled court admonishments of defendants, waivers, and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
I did, John.
I'm sorry, not electronically, but did you sign it in all the appropriate places?
I did. Thank you.
Did you understand on the lesser included offense of indecency with a child by exposure, the range of punishment for that offense is anywhere from 2 to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, I did.
Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, sure.
All right, off the record for a moment. Did you have your client sign where he put I am a United States citizen? Because signing is required.
Judge, I believe that was count 4. It was count 3 or count 4, but. just wanted to check.
Okay, you put count 4.
Okay, I did. All right.
Yes.
Judge, that was actually my handwriting there.
No problem. All right, we're back on the record. Counsel, has your client been able to provide you with any defenses to this offense?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
In my opinion, he is. He
Mr.
was.
Dyer, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney, and did you understand it?
I did, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense and count 4 of indecency with a child exposure. Punishment is to be assessed at 5 years in the prison. There are no applications. There's to be Chapter 6 compliance or regulation. No contact with Alexis and Deidre, DEIRDRERCARCE. And you are subject to the full range of punishment if you do not show up for sentencing. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
And did you understand that if you do not show up for sentencing, then your guilty plea or whatever plea you may enter will remain, but you'll be subject to the full range of punishment, which is anywhere from 2 to 10 years in prison? Did you understand?
Yes, sure.
Defense is at the plea bargain agreement.
It is, Judge.
State is at the plea bargain.
Yes, Your
agreement.
Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically? Did you sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, have any such motions?
There are not, Judge.
Then to the offense, the lesser included offense of indecency, child exposure. How do you plead? Guilty, not guilty, or no contest?
no contest. Your Honor.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1, its attachments into evidence.
No objections.
Mr. Dyer, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
I did, Your Honor.
Did you sign it in all the appropriate
All
places?
the appropriate places.
Again, did you understand? You have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent.
Yes,
Did you understand that today the state will be presenting evidence in the form of the witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Ms. Ferguson or Mr. Dyer, can I have a 2-week reset for sentencing, please? All right, we're gonna come back on April 11th at 9 a.m. Is there going to be victim impact or not?
I believe so, Your Honor.
All right, we'll do April 11th at 9 a.m.
Judge, is it possible to do the following week on the 18th?
All right, and Ms. Ferguson will give you a
All
reset.
right, thank you, Judge.
Do you have the compliance hearing on which you've been? All right, can I see Ruth Marisol Trevino? Good morning. All right, Ms. Trevino, I received this request where you want to travel.
Yes, Your Honor.
So where are you going? You're going to Monterey. How are you getting there?
We're driving, driving with my parents and my family and my sister's daughters.
All right. Steve, have you had a chance to review the request for travel?
Yes, Judge, I did.
And do you have any objections to her traveling?
No, Judge, and I believe there's been no violations for PO.
All right, then Ms. Reyes?
Yes, ma'am.
Oh, there you go. You switched, I'm looking for you on the screen. All right, then she'll be allowed to travel and then we'll do a UA upon return.
Okay.
All right,
Thank you so much.
All right,
Thank
you're
you.
welcome. Just 1 second. Is the attorney here on Anthony Villarreal?
Council's present, Your Honor.
Good morning.
He's here. Did you want him up here as well?
Yes, well, before he comes up, have you had a chance to confer with the state?
I have not conferred with the state on. I have reviewed the violation.
Okay, confer with the state and then we'll take it up. Thank you.
You mind if I borrow your copy to show them?
Sure. All right, and who is here on Maurice Brown? Okay, Manuel Rodriguez.
Here.
All right, so what is happening?
I think it's just a second setting, Judge.
That's correct.
Maybe I have-
There's
Oh,
two, there's two.
Yes, so where's it? Yeah, I'll have to check. This one. Yeah, this is the one that was dismissed. So I don't have the other one.
Had to have been Felipe.
I'm all right.
Yeah, I don't know this one.
No, I'm not gonna stick around if you did.
Maybe it's in that.
You know what that means?
You better be a witness.
Okay. All right, so, yeah, this is not really the first setting for this. So what's happening with this?
I mean, we've conferred, Judge. I don't know if we're at an impasse as far as.
Basically, I know.
All right. So where's Mr. Emmanuel Rodriguez? Mr. Rodriguez? And this is set to jury trial, correct?
Correct, Your Honor.
Hi, Mr. Rodriguez.
Yes, ma'am.
You're gonna need to be back to tomorrow for jury trial, do you understand?
Yes, ma'am.
All right, we'll see you tomorrow at 9.
Yes, ma'am.
Make sure you get a reset form from Ms. Ferguson.
Such a good amount.
And the court will not accept any plea bargain agreements after today. Do you understand?
Yes, ma'am.
All right, then we'll see you tomorrow at 9 a.m. November 12th. Just one moment.
I'm just gonna set this here for you, Judge. I have.
Oh,
confirmed.
sure, no problem. Robin, are you ready?
Yes, Judge.
State, are you ready on Anthony Villarreal?
Yes, Judge.
Let's have it put in docket, correct?
Correct. Judge.
Did you want him on?
Yes, please. And is he on full GPS?
He's on partial right now, Your Honor.
That's correct, Judge.
We did have a hearing on it, and he put his place on plan on the record, testified about his work schedule, and you gave him partial.
All right, so Mr. Villarreal,
Yes, ma'am.
we have some issues.
Yes, ma'am.
You're aware of those issues?
Yes, ma'am.
We're not on the record. This is me having a conversation with you.
Yes, ma'am.
This is the first violation report.
Yes, ma'am.
You understand what the rules are, right?
Yes, ma'am.
So what is this with Little Caesars Pizza and Texas Food Store?
If I may, Your Honor, rather than my client speak, I spoke with my client regarding these. Part of the issue was this is a case that you had granted him permission to go to his stepdaughter's child's birth. And so she had some medical issues. She was induced into labor. And so once she got out, she wasn't able to travel, wasn't able to cook. He has a wife that has some health issues as well, which you heard about at a previous bond hearing. And so his wife wasn't able to travel. And so he was just trying to get some food for
So why don't
mom.
you pick up the phone and call pretrial services?
I'm assuming that he did. I know that he's had issues
Well,
capturing.
let's find out. Did you call pretrial services?
It was late. It was already late. And I tried calling her and she tells me I got a call 24 hours in advance. And it's.
Here's the thing, Mr. Villarreal. You still need to call.
Yes, I do.
Even if they're saying 24 hours in advance, if there's an emergency, you still need to call.
Me and my GPS lady have a very, very good understanding. And he was hungry and everybody else was at the hospital.
But let me explain something to you, Mr. Villarreal. Here's the thing. If you're on GPS, I allowed you to go to work. You know how easy it is to pick up the phone and say, this is the situation. I have an emergency. I need to get food. That's all you have to do and call them and say that, because then you know what? You'll be standing here before me. And guess what? The state would tell me, well, Judge, I did speak to pretrial services. Pretrial services said he called in and said, these are the two places where he was going. And we didn't give him permission to go, but yes, these are the two places that he said he had an emergency and he had to go to. So now what I have before me is you saying this, but you didn't call anybody.
I did call, there's a 1-800 number, emergency number that you can call, and nobody answered. A recording just kept coming on, and it got later and it got later. And Little Caesars is maybe about a block and a half away. And I know that doesn't count. And the store is right around the block too. But I was home alone with my son, and I had to feed him. You know, he's a chunky guy.
You pick up the phone and you call.
Oh well.
That's what you have to do.
I called that 1-800 number and nobody
Here's the
answered.
thing. You could call the 1-800 number, and you can also call the number of your pretrial services officer. I think if you call pretrial services officer, I may be wrong. I've never had a pretrial services officer personally, but I think if you call that number and they don't answer, I'm pretty sure that you can leave a message.
Yeah, you leave a message, a recording, and they say they'll call you back.
Well, but see, but then we're back to the point. If you would have left the message, guess what would have happened? State would have called them and say, hey, did he call you? And they would have said, yes, he did. He left the message. State Defense, have you all had a chance to confer?
We have, Your Honor.
No agreement, Judge. Judge, essentially just kind of what you spoke to him about. You know, obviously, it sounds like he has a complicated personal situation, but that doesn't make him okay. He's on for a very serious charge. You know, you have given him the gift of being able to do partial. I think at this point, Judge, we would just ask that it be explained to him very quickly that he can't do that. There's no good reason for him to do that without permission, because he's on for a serious charge where he's facing up to life in prison.
I promise I will never do it again. Like I said, I will call that 1-800 number and I will leave my name. I haven't left. This is my first time getting into
Right,
it.
so here's the thing, Mr. Villarreal, I understand what you're saying. What I'm hearing from the state is they want you to be admonished. I'm admonishing you. So this is the thing. If there are some issues, some emergencies that come up in your life, you know, I've only given you permission to go to and from work. So here's the thing. You need, if there's something outside of that, call your attorney, call the 1-800 number, and call your pretrial services officer and leave a message.
Okay.
You know, I used to be a defense attorney, and sometimes my clients wouldn't leave a message, and they would say, I called you. So like, did you leave a message? Well, no. You understand?
I promise I will do that. I
Okay.
promise, sir.
All right, thank you.
Will we excuse Judge?
Yes.
Thank you.
Okay, we have 2 clocks for Lily Allen. What's the second? For Lily Allen insurance, those are those 2 files, right? No, it's just like this one. Yeah. All right, to the parties who are here on Liliana Various Contreras. I'm being told that this was mistakenly not put on the docket. Are you okay for this being set on a different day?
I've already spoken to my clients, right? We're fine. We understand it was an honest mistake. So
All right, so Ms. Ferguson, can I have a date for Ms. Contreras? All right, so we're going to come back on April 12th. Are you
Understood.
okay with
Yes,
that?
Your Honor. Yes.
Thank you so much.
Absolutely.
His 2 clients.
Who's the other one?
Erica Morales.
Just a second, we'll find Contreras on the docket.
Contreras is on 12,
Thank you.
and Morales 13.
Thank you.
She's toward the top.
Yes.
All right, and what is happening with Erica Morales?
I believe it's the same issue.
It just happened to be all of Neil's clients.
There's a magnet over the computer
So you're
system.
okay with continuing this?
Yes, ma'am.
All right, and Ms. Morales on the 12th as well? 12th or 19th?
Same day's fine, I think.
All right, so we're gonna do 12.
Thank you. Appreciate
You're
it.
welcome.
Nice to see you.
You too. Who are the parties on Jonathan Tanay? Okay. I'm assuming that I've been told this is a matter that's off docket.
That is correct, Judge.
All right, so there's a motion to reinstate bond.
Yes, Your Honor.
All right, and I'm assuming since it's off docket, your client has not been brought over because we didn't know about it because it's off docket.
No, Your Honor, in fact, but he is out. He's gonna be here this afternoon.
Oh, okay. So if he's gonna be here this afternoon, then we'll see you all at this afternoon.
I can bring him over here after lunch.
Yes, all right, 2 p.m.
Yes, ma'am.
All right, thank you.
Thank you.
Morning, Judge. I just.
Morning, hi. How are you doing?
Okay, Judge. We're hanging in there. Yeah, yeah.
All
Thank
right.
you for asking.
All right, have a good one. All right, this is 2 p.m. All right, who is on Juan Garcia Sanchez? Juan Garcia Sanchez? And so what is happening? And is he a Spanish speaker?
He is, Your Honor. Yes, my letter.
So, this is set for jury trial today, correct?
It was set for tomorrow, yes, Judge.
Okay, so we're still on for jury trial?
So Judge, there was an issue. I emailed about it last week. When we were going through the CPS records, there was an interview that was done with the victim about the specific allegations against the defendant, an audio recorded interview, and some photographs were taken, which I think the interview is the more important part of the missing discovery. But in talking with defense, we felt that both sides should have that. They have been subpoenaed through CPS and we followed up. Should be here by March 31st at the latest, but neither side has them at this point in time. And I believe this was my first time really dealing with the case. We do anticipate that it's going to be a trial. I don't think either side sees it working out.
All right, do you speak Spanish?
Yes.
Then what we're gonna do on this case, we're gonna come back on March 31st. And this, Norma, this is Juan Antonio Garcia Sanchez. So we're gonna come back on March 31st for that discovery issue, and then he'll be set for trial immediately thereafter.
Judge, just to let you know, so it doesn't seem like I came up with a last of excuse, but for the first 2 weeks of April, I've got a whole bunch of out-of-town federal settings. As long as we,
Just let us know at that time.
yeah, I just want to let you know that's not a last-minute thing.
All right, and the discovery is the CPS records and
We have some of the CPS records. We went ahead and requested everything just in case anything was missing, but there's an audio interview that I believe was done at the complainant school.
all right, and defense, do you have any objections to this being reset?
We do not, Your Honor. It was in the course of our discussions last week that we discovered this, so we're eager to look at it as well.
All right, so we'll come back on March 31st.
Yes, ma'am. Thank you.
And just don't leave before getting a reset.
Yes, ma'am.
Thank you. Okay, do you see that on the docket?
No, I don't see that one.
All right, thank you.
I think I have the wrong report.
I do have.
Oh, no, I see it.
Where do you see it at?
It's Garcia Sanchez.
Thank you.
Oh, they did call me? Oh, I'm sorry. Ooh, my bad.
You ready?
That's what I get.
Is he ready? Yeah, he's ready. All right, can I have the file? Yes. Yes, I gave it back.
It's right there.
Oh, duh, thank you. All right, who are you here for?
Judge James Madrone, we're both here on that case. We have two separate cases.
I see the drawing. All right, so what is happening with Mr. Madrone?
We're ready, and I think Michael.
Judge, so, sorry, I'm back.
Go ahead.
I guess I've never conferred with either the defense counsel before. We spoke to Pat last week, letting him know that we were ready on his case.
Okay.
He was under the impression that we were going on Rusty's case. We are not ready on Rusty's case. And so I'm not sure where we go from there, Judge, but we,
Well, I mean, you all were ready on, the defense is ready on both cases, correct?
Pat has been
I'm
under
not
the
so
impression.
sure yet, Judge, because each and every time we've had a Zoom hearing, my announcement to the court had always been the same. It was, Judge, I'm not driving this bus. This is between Rusty and the prosecution. They were far more interested in the failure to stop and render aid with serious bodily injury than they were with a burglary of a habitation. It was always my belief, and I think it was encouraged, that my case would be disposed of one way or another, either by a dismissal if Rusty's case pled, or by a dismissal if the state secured a conviction on Rusty's case. It wasn't until the telephone call last week from the state that I discovered that they intended to leapfrog my case over top of his case. So anyway, if the state wants to confer, I'm happy to confer. I came up here when Rusty came up here.
Okay, if y'all are confirmed, then we'll.
Yeah, I've conferred with Meredith.
She's not here anymore.
Well,
So, yes.
She quit when she heard she had to deal with Rusty.
So you all conferred then, confer with Marcus now.
Okay.
All right, then we'll come back. All right, the parties on Maurice Brown. What is happening with Mr. Brown?
It's an open plea, Judge. I mean, he can't be continued. I think the case is expired. I've been looking at all the long history here. So it's just not fully agreed to, Judge.
All right, court is calling 2010 CR 4913, State of Texas versus Maurice Brown. Can I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Miguel Nájera for the defense.
Are you Mr. Brown?
Yes, ma'am.
Mr. Brown, I'm going to show you what's entitled motion to revoke community supervision. Did you review that document with your attorney to get you understanding?
Yes, Your Honor.
Are you the same Maurice J. Brown who was placed on community supervision in 2010 CR 4913 for the offense of robbery on March 30th, 2011 for a term of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Judge. Violated condition number 2 on or about the 5th day of August 2020 in Bexar County, Texas. The defendant, Maurice J. Brown, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
Violated condition number 5 in Bexar County, Texas. The defendant, Maurice J. Brown, did then and there fail to report to the supervision officer as directed for the months of September 2020 and October 2020 in violation of condition number 5.
Are you saying that true or not true?
We waive the remaining conditions, Your Honor.
No objections, Judge.
All right, Mr. Brown, did you understand by pleading true to violations 2 and 5, the court would find it true, grant the motion, and sentence you up to 5 years in prison? Did you understand?
Yes.
Knowing that, you still wish to plead true to violations 2 and 5?
Yes.
Court will find 2 and 5 true. Is there an agreement?
There is no agreement, Judge. My understanding is the state is asking for revocation. Defense, the probation made a recommendation of giving him a jail sanction for the time he's been in and terminating his case unsat. And we are asking the court to follow the probation's recommendation.
Judge, from the state's perspective, Judge, and I will say once minor correction, Judge, on our court summary, it says that his underlying sentence is 10 years. I think that's in fact incorrect, that it's actually 5 years.
Yes.
He was originally given 5 years on this case originally, and then was granted shock probation by Judge Angelini. However, since that time, I believe this is a 5th MTR. He's completely absconded from probation since September 2020. Judge, I think from the state's perspective, he was given the gift of shock probation that not a lot of people get. And since being placed on probation, has just completely absconded and continually violated his probation. I think we should give him what he bargained for at that time and give him the 5 years in prison. We'd ask that you revoke him and send him to the 5 years with credit for any time he's already served.
All right, Mr. Nahara.
Yes, Your Honor.
What has Mr. Brown done since he's been on probation? What has he completed?
Your Honor, I don't have the court summary anymore, so oh, thank you. Thank you very much. Not a whole lot, Judge. It does look like at one point he was doing UAs, but then he was failing to submit a bit during that time. I don't see that there was any ordered class. He did do electronic monitoring for a period of time and the outpatient program for a couple of months back in 2018.
All right, Mr. Nahara, I'm assuming you discussed with your client what the court's options are.
Yes, Your Honor. I've gone through him and we went through the amount of back time he has, understanding that he would get credit for time served if he did get sentenced up to the 5 years. So he understood that, Judge.
All right, so how much time does he have in?
358 days.
All right, so do you want me to question your client?
Certainly.
Mr. Brown, can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and state your name for the record, please.
Maurice Brown.
All right, Ms. Brown, I'm assuming that you want me to give you what your defense attorney is asking for and what probation is asking for.
Yes, ma'am.
Why should I?
I tried to complete my probation, but I had some health issues. Here at the end, my father got sick and I went to try to take care of him. Had some other unfortunate events that caused me not to be able to report because it was a hailstorm. I lost my car. I was out of town. And I just was not able to complete what I was needing to complete.
Well, the state is saying that they haven't seen you since 2020. So that's 2 years of bad luck. Is that what you're telling the court?
Well, I was doing the because it was during the pandemic, so I was doing the Zoom meeting.
Well, I mean, this goes back to 2017, the allegations in the motion to revoke. I know it seems like the pandemic has been forever. It feels like it has been forever, but I don't believe the pandemic started in 2017.
No, man, it didn't. I don't understand 2017.
No, well, I mean, in 2017, they're saying that you not doing testing.
Yeah, I didn't do testing, but then I was revoked, and I believe and I came back and they put me back on probation. Because at that time I asked them to get a prison sentence and they denied me and just put me back on probation, but I was almost done.
Yes, Judge. It looks like he had the MTR back in November of 2017. Then another one in July of 2018.
So what health issues are you saying you have?
I've had I had 2 strokes since in 2017. And that's why my then probation officer I guess put a halt to my community service at that point. I brought all the paperwork and all that stuff from there.
Is there anything else you need to solve?
Nothing, Judge, just same position the state asked for all 5 years.
All right, court will deny the motion. You're excused.
Okay, thank you, Judge.
Thank you.
We asked to be turned unsatisfactory.
I think we have to. I think he's expired at this
Yeah,
point.
he is expired. That's why, that was my intention. He's expired. So,
Okay,
yes.
okay.
Rebecca, Mr. Brown will be, make sure that he's terminated unsatisfactorily. Thank you.
I apologize, Judge. I don't know why he didn't tell me about his health issues. I asked him, it's like, hey, the probation's saying that you just be terminated. What did you do? Like, do they like you? What's going on? He's like, I don't know.
So now we learn about this.
Yes, so I apologize about that, Judge.
Oh,
That's
no problem.
ill prepared on my behalf. My big 2 cents.
Do you have anyone else with us?
I think I'm done, and I apologize.
Are you sure?
I think so.
Okay.
For today, at least, Judge.
All right. Is there anyone else who's ready? Okay.
Just will be approved.
Yes.
Morning, how are you?
Good morning, I'm doing great,
We're here on Mr. Valles.
but I would do even better if people would pay attention to the marks that are on the floor.
I see an
Those
arrow.
are COVID guideline marks.
Oh, there's just an arrow.
Yeah,
Okay,
so, yeah,
so just stay at the arrow.
yes,
I can do that. Thank
All
you.
right,
Sorry about that.
no problem. So who do you have?
Adam Valles.
What is happening with Adam
And
Baez?
we are on the trial docket and we are going to go to trial. We've negotiated, conferred. However, we have an issue with a witness who's having surgery on Thursday.
Okay.
So we would just ask for the next trial setting would be fine. She says about 4 weeks she'll be recovered.
Wait, when is she having surgery?
Thursday.
So is there, like, how long are we expecting this trial to go?
Yeah,
I mean, the state's case in chief, I think we would be done in a day or a day and a half, depending on cross.
And we're going to be another 2. So we're probably looking at into Friday, and it is our defendant's wife who's having surgery.
What is the surgery?
It's taking a tumor out.
So why do y'all think she'll be ready next week?
No,
I
no,
know
she said
what-
4 weeks. She said 4 to 6 week recovery, but I think to come and testify 4 weeks should work.
All right. And so here's my other question. So that means that we'll be picking a jury on Tuesday. State will be finishing.
I thought we could get our case done in a day, or if at the longest, a day and a half.
What is this person
She's our main witness.
to the fact issues?
Yes.
We're gonna defer to the court, Your Honor. I mean, we're ready.
All right, do you have a motion for continuance?
I can get one on file. We just found out about this on Saturday.
All right, if you come back at 2 o'clock. and
Yes,
then the
ma'am.
Court will make it through.
Okay, sounds great. Thank you so much.
Sure.
Okay. Thanks. See you too.
Thank you. Oh. Just get what they want. And on YouTube. I don't know. I know. Maybe he'll stare me down too. I thought I was a friendly face. Nice guy, but
I'm told that's coming back tomorrow for jury trial. Yeah, he's in Washington State. Yeah, he's like, he's in Washington State. So he's going to follow her show that it's an old show.
Yeah,
And,
she's a car.
he's here tomorrow.
Yeah.
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 Mhm. Oh, no, see if Manette, because, I don't think Michael Lane's gonna be here, so the Dale Knuckle Rock can come back. Is there anyone else ready? And if I can see someone from family violence and someone from criminal trial division. And the defense file this motion, which I'm reviewing the case law network. This is request for return of property.
Okay, Judge.
Judge, I think this was actually set last week, just a motion for continuance. I mean,
Yes, but he's basing it on, he thinks that the law has been declared unconstitutional as a statute.
Yeah.
So I'm researching that. So
Okay.
y'all may want to
Yeah,
research that.
okay. All right, thank you.
Sure, the public. And Crystal Martinez, can you give me the file on Crystal Martinez? On that one, the motion was withdrawn. The people we have remaining are Zachary Prince, Johnny Cepeda, and they're working on the job. Joe Dela Cruz, Rodney Ferguson.
No one was working.
Oh. Carlos Garcia with Scotland. And Roland Wharton. Roland Wharton and Joseph Harris. Would you like to see the song on chorus, please? Yes. Okay, thanks.
What's going on?
Yes.
Thank you. All right, Hanan Gandara. Where are we on this? Good morning.
Judge, we are set to re-indict this case. We're adding additional manner and means. We're set tomorrow to re-indict it.
We're gonna see what happens with this case tomorrow. I'm assuming this case is being dismissed.
No, Judge, our officers are ready.
Oh, so we're going forward on this case. It's Hanan Gandara.
Yeah.
So
Judge, so yeah, so we're re-indicting. If Bobby is ready to go with the new indictment, we'll be ready to go also.
all right, so I don't, you're not gonna be ready. Are you gonna be ready to go with the new indictment?
No, I don't think the burden on me is to be ready on. a
Yeah,
new indictment.
no, I understand that. So I'm assuming then you all will be dismissing this case.
Once the new indictment comes, yes, Judge.
Oh, all right, so we'll be here tomorrow.
All right, I look forward to it. It's gonna be
All
fun.
right, thank you.
Are you guys gonna have breakfast tacos?
And Judge, sorry, the reason we're waiting to dismiss is because if we dismiss before, she'll have to make bond again. And so we wait until the re-indictment comes before we dismiss the case. We could dismiss it before.
Y'all do whatever you want to do. I'm happy either way. I like coming down here.
Oh, well, it's good seeing you.
Nice to see you too, Judge.
All right. So, Ms. Ferguson on Gandara. This is reset, recall for tomorrow. Hi, how's it going?
You didn't make your custom or shield? I see yours is different with a little cutout. Is that a custom shield? or
No, they
all-
gave that to everybody.
Okay. Everything's a little different. Anyway, all right.
All right, is that Mr. Torres?
Yes, ma'am.
All right, let me put something on the record,
Sorry.
Mr. Torres. Torres, I'm just gonna place on the record because your defense counsel is not here again, so I told you that if they didn't show, we would appoint you a new counsel. So I just wanted to make sure that you're okay with appointing a new attorney, okay?
It is fine.
All right, we're gonna go on the record, Brenda, and cause number 2021 CR 11493, 2021 CR 11492, 2021 CR 11491, 2021 CR 1475, State of Texas versus Abelardo Torres for the state.
Brian Groomer for the state of Texas.
And are you Mr. Torres?
Yes, ma'am.
All right, Mr. Torres, your defense counsel was scheduled to appear on January 25th, was not present. It was recalled for February 24th. Your defense counsel was not present. On February 24th, you informed the court that you wanted a new attorney. Do you still want a new attorney?
From Ed Camaro, yes, ma'am.
All right, and so on, when the defendant requested a new attorney on February 24th, the court reset it for March 1st to give the defense attorney a chance to appear. The defense attorney was a no-show. Then the case was reset for March 15th, and the defense attorney was a no-show. So now it's being reset again for March 21st, and the defense attorney is a no-show. The court coordinator has made several attempts to contact the defense attorney, has been unable to contact the defense attorney. The court has appointed a new attorney for you, and that new attorney is Mr. Miguel Nahara. And Mr. Nahara, if you just state your name for the record.
Miguel Nakara for the defense.
All right. And Mr. Torres, as you're aware that Mr. Nahara was just appointed today, so he hasn't received any documentation from the state as yet. So I'm not going to push your attorney to trial today because he doesn't have any information on your case. But as soon as your attorney informs the court that they've received all the information and your attorney has received an offer from the state and to that offer to you, then we'll set it for a jury trial date. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
All right, Ms. Ferguson or Mr. Torres, can I have a 30-day reset, please? All right, Mr. Nakara, we're gonna come back on April 28th.
Yes, Judge. Let me put it in my calendar right now.
Thank you.
You want the actual FBI trust card? We should know exactly. That's the only way I understand. Yeah, because it's just like a summary of the detective saying compared to anything. Like, you know, let's say my fingerprint, they have a fingerprint, they'll have it on card, essentially, they'll just compare it.
And I actually conferred with Mr. Groomer a little bit. He's unable to give me an offer right now, but he's going to give me a chance to download all the discovery and get an offer with me. I'll try to visit my client even before the next setting.
Sure, okay, thank you. And we all both have your reset day, so if you finish with that, if you do with that.
Thank you, Judge.
Hey, Judge.
Johnny Tejeda. Judge Tejeda status already. This is one where we plan to consolidate the 3 cases. Additionally, it's a lot of witnesses, and I told Alex I would try to get it set to where we knew for sure it would go because we have witnesses from, or we would have a better idea of if it would go. Because we have witnesses. So we're asking for this Judge.
You know, my client does assert his right to a speedy trial. I understand the state's concern, but I don't really want to fight with them because if they dismiss it, they'll probably just refile it. And so.
We'll see you guys back tomorrow. See you tomorrow.
Okay.
All right.
All right.
It's just a
9?
Yes, 9 a.m.
All right. Thanks,
Ms.
sir.
Ferguson, Canada is 9 o'clock
Do
tomorrow.
you need a reset or?
Yes.
Yeah, I can remember. I'll write it down.
Just I was trying to like 2011, it should have expired in 2021, but I guess he was extended at some point. Yeah. Hey, Judge, just one little. Sure. It's a gorgeous bracelet, by the way.
Oh, I know. Yeah.
He was extended. I heard the conversation.
Yes, well, Mr. Brown, I was incorrect. We thought that his case had already expired, but it hasn't. It expires on the 29th. So this honorable court has two options. Obviously, at this point, since you've denied the motion, you can
So
either
when is he expired?
the 29th, so in 8 more days. That's when he expires.
I'm just trying to make him upset.
Okay.
All right, thank you.
Thank you, Judge.
Sure, no problem.
Good morning, Judge.
Good morning.
I have a couple cases to announce on.
You want to tell the clerk what it is?
I'll do that first. I'm sorry. I know. Oh, Zachary Prince and then Carlos Garcia.
This weather's getting to my knees.
All right, Zachary Prince.
Okay, he is present, by the way. If you remember, he was coming in from out of town and he got here late, so he's present now. What do you think, Michael?
Judge, it's just a fact-intensive case, and due to my honeymoon on Friday, I know that's not a valid reason for a court to move a case, but it's not a case that we can get done in a week. Because I think I don't know if he has, I don't think he has any experts, but we're gonna have something on it.
We'd like to pass it to the next trial setting, I guess, if you would, or however you do these things. I know you want to get it moved. He's on bond though, but I know we'll be ready on the next one.
What is the next week? for jury trial?
Won't be in Goldie. I come back for the 4th because I have a funeral that I have to go to in Belize right after my honeymoon. It's gonna be a great time.
Start it the day you get back.
I can look at the file at the funeral. Might as well be stabbed.
Look at him. For the 12th. All right, great. So we can do April 12th. I think that will be Angela me trying that, but okay, we can do April 12th.
Okay, all right. That's the punishment I deserve.
Yes, April 12th. Are you okay? with
Very
April
good.
12th?
Yes, thank you.
Thank you, Judge.
All right. All right, give him a reset. All right, and then Alejandro Carlos Garcia.
Yes.
Yes.
What is that set for?
Set for trial.
Judge,
Yes.
well, I didn't know that was that. I think my answer was going to be, I'm looking into a couple of discovery things for Mr. McCrum. There was a phone dump done at the time of the case, which I'm going to get him later this week. He's also asked me to look into a report regarding a fingerprint. Right now, I'm trying to get those. In addition, he has a pre-indictment aggravated robbery out of the same timetable that we are looking at indicting.
All right, have this come back on March 31st, and all the discovery should be done by then.
Thank you.
You're welcome.
Yeah.
Oh, sorry, let me write bummed up from there. Yes. What is happening with Mr. Joe Dela Cruz?
We're waiting for,
Okay. All right, thank you.
Hello, John.
Yes.
How are you doing?
Oh, I'm doing great.
Doing okay. I scheduled a meeting with you or inquire as to a voucher.
I'm sorry.
Can I schedule a meeting with you or inquire as to a voucher that I had submitted?
All right, so this would have been one that went to the voucher committee. So it would probably be best for you to schedule a call with the voucher committee.
What's funny is I did, and not this court, but another court, and they sent me back to the judge, and then the judge says, no, it's a voucher committee. So I'm bouncing both ways. So was this the voucher committee? Because I'll go back there again.
Yes, because I don't sign when it's what do you call it, when it's itemized, it goes to the voucher committee.
Goes to the voucher committee. Okay.
Can you check on this one for me and see? To see what the voucher committee said.
And I understand, and I don't mean to bombard
Oh,
anybody.
no, no, no. No problem.
It just went from 15 to 5. I have another one that went from 5 to 35. I was like 1,500. And I was like, these sexual assaults. I mean,
Oh, yeah.
I'm working them up, and I says, I'm working them out, not trying a case, saving a jury, trying to work them out. And they're like, "Huh." And I was like,
Yeah, no, it goes, like, they actually went to jail. When it's itemized.
It should be in the file.
Yes. So,
on the last one, they cut it and said, you didn't get authorization to go over 30 hours. And the judge is like, here's my order. I mean, the order's there. And so this one, I didn't go over 30, but it was just such a reduction that I thought I'd ask.
okay, yeah, so we'll see. So it's whatever they review.
Have you ever had someone like resubmit one saying, no? This girl ran to Mexico. I had all these conferences trying to get her back, picking up new cases. And that's the worst, is when you work up a case and then they pick up new cases. You don't get paid for more cases.
But yeah, so he'll be able to pull it and you can see
What their reason is. Thank you.
Sure, no problem.
How's everything else going? Is there a lot of new legislation coming down on settings? That's what I hear. So we're gonna have to loan up on all that.
Yeah.
It's been withdrawn.
Yes.
You don't need to see the advance, right?
Yeah.
Okay. When it's been withdrawn, she doesn't. Okay.
All right, Ms. Martinez, good luck to you.
Thank you.
All right, do better.
You want her to sit there? This week there. I'll take you right now.
Yes.
Yeah.
I saw you chose her.
David Oz will treat you like me. Like these three.
Okay, this one says. So let me show you what the main make was. But then this is the amount they pay. The 57750. So I think they may have made a mistake.
And the last court let me take a copy of that. Can I make a copy of just the first page?
And so
I have a scanner. I can just.
Yeah, and ask them what they need, because the amount they gave me, as you can see, was the 577.
And the only thing I can think of is when you turn it, that's what was paid. Left off that out.
Okay.
And but it was close. It was 577.30 instead of 50.
So yeah, if you can scan that and then ask them.
Okay.
Because I go by what they put on there.
But
Well,
I
it's
don't
a good
mean
thing you checked.
I don't mean to gripe, but I'm like, that's tuition.
Yeah. Right, so just ask them what they need. And if they meant for the entire amount.
And look, it says 577.50. It came back 577.30.
Yes, I don't know why that's it. So if you will.
I'll hunt them down. I have contact for them and everything. Thank you, Judge, very
You're
much.
welcome.
And thank you. Appreciate it. Made it painless. It's good to be back in person.
All right. You too. Bye-bye.
Thank you, guys.
So on that, I've got paid the 500 because that's what they put the pay amount as. But then they say pay is submitted, but then they put 500 and something dollars. Well, we don't know. Can you, See if you can ask Tom, or, I think John Robertson is on that. To ask them what do they mean.
No, it's.
Okay, everyone, we're gonna take our break then. All right, everyone, the court is gonna take its break. We will be back at 2 p.m.